We go back over to Cora Henderson over at Pitt and Frank LLC. Sydney sent us an email with a question that everyone needs to think about. So, Cora, Sydney's mom wants to make sure that Sydney gets the home that her mom owns when she passes away. And she and her mom are wondering, should mom put the home in Sydney's name now or wait and then leave it to her in the will? Her mom apparently is worried about the tax consequence of putting Sydney's name on the home right now. Any thoughts on that from a legal perspective?
Absolutely. I have a lot of thoughts on that.
Yeah.
So stay with me here. I think that it is certainly fact derivative, and we would love to have a consultation with them to understand what option best suits their needs. But things that we should be thinking about whenever we make those considerations, such as quitclaim deeds, certainly there's going to be a tax implication to that. So, having those conversations with your tax specialist is very important. Secondly, from an estate planning standpoint, typically we like to see that reserved in the will. We like to see that reserved in estate planning tools, but maybe a trust is a better vehicle based on that fact pattern than per se, just a will. Maybe the asset should be titled in the trust. For instance, if there are concerns about Medicaid and having her mother, with a home and the look back period and so on and so forth, if we're worried about the government coming in and subjecting and pulling in that home, that asset to pay off the debt for the care that she had been receiving after her death, that could be a problem. They could see that as a gift, even if it is titled in Sydney's name. So there are certain tools that we can use as attorneys and certainly elder law practitioners who are able to preserve those assets as best as possible from those types of scenarios. For instance, one popular vehicle would be a irrevocable trust in that scenario. Yes, you can add Sydney to title. If you do, you would want to use certain language such as joint tenants with rights of survivorship, meaning that then makes that asset become subject to titling and it is a non-probatable asset. So it actually wouldn't be drug into their estate. It would pass outside of probate because we titled it on the deed that way. But again, it has tax implications. So there's a lot of advantages and disadvantages that may be more important to some than others that really precipitates a need for a consultation, a well-designed, thought-out plan for our consumers so we can make sure that we accomplish the best goal in mind for them and something that's going to leave all parties better off for, and not something where, they're looking back going, gosh, I wish I had not jumped the gun, had not placed her on deed and titled it wrong.
Cora, back up for a second. You mentioned
Please.
something about the government going back to see if to pay off healthcare, nursing home, assisted living. How far back because I'm thinking there are a lot of people listening right now. So did they make a mistake? How far back does the government go when they're searching?
So my understanding is that there's a 5-year look back period there, but a lot of our elder law specialists here in town, we can certainly give you some referrals. They'll do free 30-minute consultations for clients. And so I think that's very important, especially as we're headed into the holidays with our loved ones. And maybe we notice that mom or dad or cousin, doesn't seem to be in quite the same health. We should be cognizant of that and having those opportunities, especially those free consultations, to say, what does that look like if we started to plan ahead? Because waiting until maybe the memory has deteriorated or their health has deteriorated could impair not only the possibility of preserving all the assets, but also an opportunity, an easy opportunity to capture their signatures with their capacity to sign those legal documents. And that goes along with whether you're doing estate planning, formulating a trust, making deed changes, or a power of attorney. So that's very important that you're having those conversations before things start to go south, before, someone gets in bad health and is maybe hospitalized. And I know that's a morbid conversation and you don't want to go home for Christmas going, hey, mom, I'd really love to get you into that elder law specialist. But I know a number of people that we work with, they treat those consumers just beautifully. I mean, just having those delicate conversations, those sensitive conversations, they do it in a manner that really is disarming and in their best interest. And it's not in a predatory or vicious way. So just with anything else, selecting the right person to work with matters.